These are Muslim values. These are Canadian values.
I think it is extraordinary that Mark Carney has become the Prime Minister of Canada. He did a terrible job in Britain.
Look inside yourself, Rosemary.
And our party stands for the right of freedom of expression and freedom of religion, which is under attack by this particular poison pill block amendment.
In Canadian federal politics, the Canucks are represented by two separate yet unequal groups, the globalists who sold out and the opposition trying to salvage a country. These are their stories.
Now, Mr. Fortin tried to frame this as a philosophical, intellectual divide between the Bloc's position and the Conservative position. And I think indirectly painted the picture that it was the Liberals who are the moderates here, that it's the Liberals who are trying to bridge this philosophical difference between the two parties. And I've said this numerous times, and I think it bears mentioning again. And I'm going to turn to the officials for greater clarification on this. Bill C-9 was introduced by Justice Fraser, Minister of Justice Fraser, in the fall of 2025. Nowhere in the draft of the bill was there any reference to the Liberal government seeking the removal of a 56-year-old defense under Section 319. And I say that, I've said it numerous times, because it's important for all the stakeholders and Canadians who are watching this, that the Liberals are by no means the saviors here trying to come up with an agreement that everybody can live with. The Liberals never intended, when this bill was drafted, when this bill was presented, when this bill was debated at first reading and at second reading, and when this bill was actually studied, and I don't know how many meetings, Mr. Chair, we've had in terms of this particular bill and how many witnesses were called, not one specific expert witness or subject matter expert on the issue of the removal of this decade-old defense was ever called. Now, Mr. Fortin, as he had every right to do, made it abundantly clear that this was ultimately his position and used pretty much every opportunity to expand upon his concerns about the removal of the defense and to get some evidence from some of the witnesses. I don't recall any Liberal member on this Justice Committee ever expressing or displaying any support for Monsieur Fortin's line of questioning to remove this religious defense. Until late in the fall, when we as parliamentarians received the news that one weekend that the Liberal government, ostensibly by Sean Fraser, our Justice Minister, had decided to create a backroom deal with the Bloc Québécois that in exchange for the Bloc to support passage of Bill C-9 at all stages, that they would now, some, 6, 7 months removed, now saw merit in removing a 56-year-old defense. So with that as the backdrop, officials, please help me with this. Were both of you ladies involved with all the stakeholder consultations that Sean Fraser engaged in terms of formulating his position on how he would instruct you to draft the original Bill C-9? Were you part of those stakeholder discussions?
And engaged on some and through our own processes as well, where officials have direct engagement with stakeholders, but we are not party to all of the conversations that the Minister's office has with stakeholders.
If you know, if you don't, you don't. But when can you tell us that those discussions began?
And which discussions are you referring to specifically?
In terms
Mr.
of creating the anti-hate bill, Bill C-9.
So elements of it were part of the government's platform, including the proposed new offenses for obstruction and intimidation. You'll also recall that other elements, like the proposed new hate crime offense, were part of former C-63, so have already been introduced. So work on this issue and these related issues have been ongoing at the department for several years.
But after the spring election in 2025, we as parliamentarians were led to believe, because of statements made by the Justice Minister and other ministers and the Prime Minister, that extensive discussions and meetings took place, which enabled the Justice Minister to deliver instructions to his department to create Bill C-9. How soon after the election, if you know, tell me please, how soon after the election did those meetings start? And when did they end? And when did you get instructions from Sean Fraser to create Bill C-9?
I can't recall the dates. I mean, I think what I can say is the department has long been working on these issues. Part of our role at the criminal law policy section is to be ready.
Just a reminder, gang, smash the like, hit subscribe. We work really hard at this stuff. Let's get back to the video.
When asked to prepare. And so I think to be
Give
helpful.
me exact dates?
I can't give you an exact date.
That's fine. I didn't think you would have that, and that's fair. But is it also fair to conclude that some of those stakeholder discussions, whether they be in person, whether they be Teams
Chair.
or
have a point of order.
Zoom, or simply exchanging correspondence, also included stakeholders from the province of Quebec?
Mr. Brock, sorry we interrupt, but we have a point of order.
Sorry, I have a point of order, Mr. Chair. I don't know where the line of questioning is, how that is related to Mr. Lawton's sub-amendment. I think that we're still on Mr. Lawton's sub-amendment with regards to removing the last line of my for greater clarity, certainty clause. Is it not, Mr. Chair?
That's a fair point of order, Mr. Brock. Perhaps you could bring it back in. Yeah, that's all. Yeah.
I've got lots to ask and lots to say.
Understand the pertinence of this questioning on consultation, and if officials were on consultation process, how that is related to Mr. Lawton's sub-amendment.
I'll get to that, but I'm not going to be put on a clock by you, Ms.
All right, but
Latanzio, or anyone else.
the back and forth, it's a fair point of order, Mr. Brock. We have to keep it relevant, so carry on.
Fair enough. So I think I formed the question before I was interrupted with a point of order. Any discussions whatsoever with stakeholders from the province of Quebec?
All specifically, I can say generally that the department, at the very least, does have broad opportunities to consult with all provinces and territories.
Okay. Do you recall, if you were party to these discussions or received information from the Justice Minister, of any stakeholders prior to the creation of Bill C-9 specifically asking for the removal of the religious defense as contemplated by the Block Amendment? Yes or no?
I think what I can say to that, Mr. Brock, in the interest of being helpful, is that we have been aware at the department for a long time that the good faith religious defense exception has been of concern for various stakeholders, and that there are various views on it. And I think to bring it back to your opening remarks, You will see that when, and you know this, that when C9 was introduced, as you indicated, it was not part of the proposed legislative package.
Because it wasn't a priority for the Liberal government at that time.
I can't speak to the priority. I can
Well,
tell
we
you it
can
wasn't
read
part of the
between the
C9
lines.
package.
If it were a priority, common sense would indicate that we would have saw some reference in Bill C9 from the Liberal government telegraphing a removal of the religious defense that the religious community in Canada has enjoyed for 56 years, a law that was created by a Liberal Prime Minister, Pierre Elliott Trudeau, in 1970.
Sorry, question? I'm just,
No, it's,
Okay.
I'm putting a statement on the record. Okay, I will ask questions, but I just wanted to put that on the record. Thank you. Were you privy then to the change in direction that the Liberal government made in late fall of 2025 to agree with the Bloc that they would seek the removal of this defense? Were you consulted beforehand? And I'm not asking what the opinion was, so don't claim solicitor-client privilege, but were you asked to
Mr. Chair,
provide
point
a
of
legal
order.
opinion?
Mr. Brock, we have a point of order. Ms. Latanzio?
Mr. Chair, again, a question of relevance. We're not discussing, or the questions to officials
Okay, for relevancy, I'm
are
going to go
not-
back
Just
to the,
Mr.
to the
Brock,
sub-amendments
I'm
and
going to
Andrew
hear,
Lawton.
I'm going to hear the point of order,
Okay.
Mr. Brock. Go ahead, Ms. Latanzio.
Again, the questions or comments being made to officials or to this committee have nothing to do with Mr. Lawton's sub-amendment. And it is very clear what is happening before our eyes yet again. So, again, Mr. Chair, can we just keep the questions or the comment relevant on Mr. Lawton's sub-amendment?
Yeah, I think we all agree on that, and I agree that the individuals here are responsible for drafting based on instructions, Mr. Brock, so maybe we can keep that in mind.
Yes, well,
Thank you. Carry on.
officials, were you involved in the drafting of Ms. Latanzio's amendment?
Of the legislation, I said.
Of this particular amendment that we're discussing today? Sure, so
C9.
there's my relevancy link, okay? So you have been involved with drafting.
Bill
Not-
C9 is what I said, sorry.
Exactly.
Yeah, and then
Right.
we continue to provide support to our minister's
Absolutely,
office
so
as
there
requested
is
on
my
various
path
issues.
of relevancy, all right? So Ms. Latanzio can continue to interrupt for the next 15 minutes. I'm not going to prevent her from doing that. That's her absolute parliamentary right, but it's also my right to ask relevant questions. And relevancy is subjective because I have the right to ask questions that allow me to put a foundation before you before I actually talk about the merits or lack thereof of Ms. Latanzio's amendment.
Sorry, can I clarify? Was your answer that you were involved in drafting the legislation but not the amendment, correct?
To clarify, my answer was that we were involved in the drafting of the bill, and that following the introduction and to the committee study of the bill, we continue to provide support to the minister's office on the parliamentary process.
Support.
Thank you.
Okay? And by extension, support could also include aiding with the drafting and the specific language used in Ms. Latanzio's amendment known as 11.1 sub 1. Correct?
So I'm mindful now of maybe where we are on the line of solicitor-client privilege, and I am aware of
Asking
as well
you
as
for the
parliamentary
advice you
privilege.
gave.
So I think the only way I can answer that is just to continue to reiterate that we do support the minister's office in this area.
And the minister's office, by extension, includes his parliamentary secretary, correct?
I mean, presumably, but we don't see that distinction all the time. So our direct correspondence is with the minister's office.
I get that, but there's one parliamentary secretary assigned to every single minister of the government. I can understand why you wouldn't be consulting directly with Mr. Chang without insulting you, Mr. Chang, with all due respect, or Ms. Dillon, or Mr. Housefather, but it's obvious that Ms. Latanzio is an extension of the Minister of Justice. So she would be included. Whether you want to agree with that or not, I think it's just common sense that you would include a parliamentary secretary. So again, I don't want you to say this is governed by solicitor-client privilege, but were you asked to provide a legal opinion prior to the declaration that was leaked to the national press in late fall of 2025 that the Liberal government was now prepared to agree with Mr. Fortin's amendment to remove the defense? Were you consulted, yes or no, by the Minister of Justice?
Mr. Fortin has a point of order. Go ahead,
En
Mr.
tout
Fortin.
respect, Monsieur le Président, je pense pas que la
Respectfully, Mr. Chair, I don't think that our colleague Mr. Brock's questions are relevant to our.
We'll get back to the absurdity of Canadian federal politics in a moment. Just a friendly reminder to smash the like, hit subscribe. Please leave a comment below if you have something to share. Let's get back to the nutty video.
Debate. The questioning is going in the direction of undermining or questioning, rather, the credibility of a witness. And here we have officials of the Justice Department who are there to clarify points of law with regard to the legislation that is before us and the amendments thereof. So to ask them whether they took part in the positioning of the government in favor or against an amendment to the bill or a proposed amendment to the bill is not relevant. I agree that our colleague, Mr. Block, can ask questions about interpretation. I mean, Mr. Lawton, I'm sorry, I said Mr. Lawton, but in fact it was Mr. Bobber, but who was asking how should I interpret such a passage in the proposed amendment. That's fine, but to ask whether Ms. Wells participated in discussions with Mr. Fraser and Ms. Latanzio in October, and whether they said that they were possibly in agreement with an amendment that the Bloc proposed, I do not see a link of relevance, and it does not advance us in the text that we have before us.
Mr. Brock, I'm inclined to agree, with Mr. Fortin, rather. I mean, you can ask questions about their interpretation of the language that we're discussing. You can ask some questions about the drafting of the bill, but getting into discussions they had with the minister and, by extension, the parliamentary secretary, we're treading on dangerous ground, and it's, in my opinion, it's not relevant. So if you could sort of maintain those goalposts, I would appreciate it. Thank you.
Thank you. Thank you, Chair. I can move on. So I listened very carefully to Mr. Housefather's intervention. And Mr. Housefather essentially said that there's a great deal of misinformation. And although he didn't point any fingers, I would certainly surmise he wasn't looking at his bench, certainly wasn't looking at Monsieur Fortin, but by elimination, he was probably accusing the members here of the Conservative Party of being the authors of that misinformation. And when challenged, when that comment came out, I raised the comment, and I'm sure Mr. Lawton did as well. We both suggested Mark Miller. And I recall Mr. Housefather saying something to the effect that Mr. Miller did not say what we were alleging that he did say. So I actually have the transcript of when Mr. Miller, who's now a minister of this Liberal government, was in your chair, Mr. Chair, and this was a question, a follow-up question after all the rounds had been exhausted to Mr. Derek Ross. And it reads as follows. I'll use Chair's prerogative to ask a follow-up question of Mr. Ross. As despicable and as unlawful as the statements made by Mr. Charkawi are and would be if they were stated again, we don't know why the prosecution chose not to continue with the charges. Perhaps this is to Mr. Fortin's point. I want to dig a bit into the concept of good faith, Mr. Ross. In Leviticus Deuteronomy, and Romans, there are passages with clear hatred towards, for examples, homosexuals. I don't understand how the concept of good faith could be invoked if someone were literally invoking a passage from, in this case, the Bible, though there are other religious texts that say the same thing. How do we somehow constitute this as being said in good faith? Clearly, there are situations in these texts where statements are hateful. They should not be used to invoke or be a defense. Now, here's the important passage. There should perhaps be discretion for prosecutors to press charges. I just want to understand what your notion of good faith is in this context, where there are passages in religious texts that are clearly hateful. That was, Mr. Chair, before the agreement was reached between the Liberal government and the Bloc Québécois that had absolutely nothing to do with what's in the best interests of this country, but what's actually in the best political interests of this Liberal Party and Liberal government. And Mark Miller, who is now a minister, sent a very strong message, sent a chill down the spine of every single religious leader, follower, and everybody in between in this country that this Liberal government has now declared war on freedom of expression and freedom of religion. That notwithstanding some of the passages that this minister referred to are over 2,000 years old, he invited prosecutors to press charges. So with all due respect, Mr. Housefather, that, sir, is misinformation that did not come from any Conservative member. That came from your colleague, your minister, Mark Miller. He lowered the gauntlet. He created the division that we are now seeing in this country. And all the peddling that this Liberal government is doing right now with language trying to placate Conservative members, trying to placate our party, trying to placate all religious leaders who have written every single member at this committee. I know that there are civil liberty groups who have jumped on the bandwagon and saying, how could this government wage war against our protected charter rights? Why attack? And to Mr. Housefather's point, I agree with him. That religious defense has not been successful at all. But does that give license to this government to actually take steps to remove a religious defense that has guided and protected good faith discussions, statements, and opinion across this country? Absolutely not. To the officials, when was the last time a federal government actually removed a statutory defense in the criminal code? You have any idea?
It does happen.
Yeah. Do you know how long ago it was?
If you know the answer,
Yeah.
please, you can remind me.
2015. Okay? And prior to that, 2015 was the narrowing of the provocation defense. Prior to that, it was 1995, which was the limitation of the extreme intoxication defense. And even further prior to that, in 1983, the repeal of the marital rape exemption. This doesn't happen a lot, does it? In legal jurisprudence, that we actually take as a government legal steps to remove a statutory defense.
In my experience, it's more likely that that offenses are added. There aren't many statutory defenses. A lot of it comes from the common law as well, as you know, Mr.
And you'd
Clark.
agree with me that quite often when statutory defenses are removed, that largely it's guided by common law decisions?
I think that's true in some cases.
Right.
I'm not intimately familiar.
Right.
I'm aware of the examples that you cite,
And
but
in
I'm
this
not intimately
particular,
familiar with
on
them.
this particular issue, there is no common law decision out there that would give license to this Liberal government to now make a political decision where they had ample opportunity during the drafting of Bill C-9, where they had ample opportunity to debate this issue in the House, where they had ample opportunity to debate this issue at Justice Committee, now to say, we think this is the right thing to do for this country. They made that decision on their own. They did not make that decision because they were guided by legal decisions across this country. Is that fair to say?
What I understand is reading of the Keegstra decision, which is not an immediate decision. It is an older decision, but using that guidance, the ministers of the view that the good faith religious exemption defense, given the way that the offense was interpreted in Keegstra, doesn't do.
And when was Keegstra released? What year was it released?
I have to look it up. It's, I think, in the early 90s.
It certainly wasn't in 2025.
It was not 2025, correct.
No. In fact, it wasn't even in this century, was it? Wasn't in the century.
I believe it's 1990, but
Exactly.
I would have to confirm.
Thank you, Chair. That's my time.
Canada's broken because we're stupid.
I think it is extraordinary that Mark Carney has become the Prime Minister of Canada. He did a terrible job in Britain.
Canadian federal politics are absurd. We're going to stick a fork in that video. It's over. My name's Aaron. This is Canadian Looney. Smash the like, hit subscribe. Please leave a comment below if you have something to share. Enjoy this playlist. Check out this video. We've got lots of things to watch. Aaron, Canadian Looney. We'll catch you in the next video. Thank you for watching this one. Ciao for now.